Pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, this meeting is called to order. I just want to remind people a couple of things. First of all, will everyone turn off or mute their cell phones? We had a little problem last meeting where we kept getting interrupted. If you cannot turn off your cell phone or don't know how, please take it outside. Okay. The other thing that I want people to know is that this is a regular board meeting, and so it will be run as a regular board meeting, which means that we only take questions, issues from the floor after the meeting. In addition, like all of our board meetings recently, this meeting is being recorded. So if you don't, or are unwilling or worried about being on, there's a camera right up there, if you're unwilling to be on a recording, you need to leave, because we're doing that so that the people who are not here can see what goes on at the board meeting. Okay, now we're going to have roll call. I'm going to start first with the people. We have two board members that are on the phone, so I'm going to start with them first. Judy Weir.
Here.
Sandra Lester.
Here.
Okay, so the two of them are on the phone, and I'll start down at the end with Terry Langton. David Humphreys.
Here.
Bob Turner.
Here.
Gary Jones.
Here.
Bonnie Richter. So all of the board members are present, and we have established a quorum. Now, we're going to look at, you've got the agenda in front of you. Can I have a motion to approve the agenda?
I make a motion to approve the agenda as posted.
Okay, Gary made the motion, Humphreys second.
Right.
Any discussion? Okay. All those in favor?
Aye.
Okay. The agenda is approved as posted. Okay. I got eyes on the board. Did I get two eyes on the phone?
Yeah. Aye for me.
Okay.
Aye for me.
Okay, that's two. You guys sounded like on the phone, that's why I had to listen to that. Okay, so I have a motion on the floor and a second. All those in favor of approving the agenda?
Aye. Aye.
Any opposed? Any opposed? Okay, the agenda is approved unanimously. Now we're going to look at the minutes from the board meeting of June 4th. And everyone has had the minutes. The draft has been posted. Can I have a motion to waive the reading of the minutes and accept the minutes as posted? Judy made a motion to waive the reading of the minutes and approve the minutes as posted. Can I have a second?
I will second it, Sandra.
Okay, Sandra second. Okay, all of those in favor?
Aye. Aye.
Aye.
Any opposed? Okay, then unanimously approve the minutes as posted. Okay, now we're going to the meeting. We're just going to flip the order of the new business. So we're going to start with the ELS early access for the inspections, and I'm going to turn it over to our attorney, Mr. David Bernstein.
Good evening, board of directors, shareholders present. Thank you. And I wish to alert you to, and I know you have copies in front of you, the negotiations that have taken place over the last couple of weeks since our last meeting to come to terms on the early access to allow ELS to get started on an inspection without committing the sale until a vote. But the vote is scheduled. The letter of intent is circulated, and everyone has a copy of that. This is the same letter of intent that was distributed to all of the shareholders with the same terms. Knowing that there has been some rumors and concerns about whether ELS would stay committed to this process, and knowing that they have issued their letter of comfort to the board and to the shareholders that they are standing by awaiting the vote. And knowing that there was concern among shareholders about a loss of time, the hurricane season, the ability to get through inspections sooner rather than later and not postpone those. Since the vote could not take place in May and will now take place in early August, the board considered prudently trying to move this forward. There is a lot of homework for a buyer of this community to undertake. I've been talking with their lawyers and coming to terms with them on undertaking that. They would start their inspections at their expense, would be no expense to the corporation. They would go through the process of looking at the business records, and of course that means the rent rolls and the income and expenses, your audits, things they would normally do in buying a business. And then on top of that, do the physical inspections that take time. If they get started in June and July, as we would anticipate under this agreement, then we would not have to wait until after the vote at the end of August, or worst, possibly toward the end of August, before a contract is signed for them to do that should the vote go through. Should the vote not go through, which frankly at this point is not anticipated, then of course at no expense of the corporation, they have undertaken this on their watch and have wasted their money. So we're very careful to be sure there is no harm here for the corporation. On the other hand, only benefit. Now, this letter of intent has been on the table. It was voted on initially by the board before it was taken to the shareholders. And the shareholders, of course, have had the workshops, the meetings, and received the information based on the letter of intent. The terms are exactly the same, with the exception of a few terms I'm going to go over with you today. I've been able to negotiate up estimated closing costs to $3 million from the original $2.5 million that was placed in here, because I have expressed to them the concerns over the delay of the closing and the potential for there to be additional costs attributable to that delay. Reimbursables to this corporation are all closing costs, all transaction costs. So to the extent there are any increases, we know that the estimate of originally $2.5 million should be sufficient, but we negotiated to buffer up another $500,000 to benefit the corporation. At the end of the day, you won't be coming out of pocket at the closing for any closing costs, but it is foreseeable that there could be some additional closing costs. We're going through a hurricane season. We don't know if we're going to be hit with anything. We don't know if we're going to have any special assessment from the county, if there's any flooding here. We don't know what could happen. We don't think that will happen. We hope and pray it doesn't happen. But in the event something comes up that requires additional cost to be incurred, we negotiate up another $500,000 on costs. In addition, I will tell you in this letter of intent that you have either before you or reviewed by email for the meeting tonight, they have specified that they would take access to this property just for the purpose of their due diligence. And therein it states specifically that they'll have access to review the contracts, the books and records, and whatever documents or data there is that relates to this property. There's obviously a lot that has to do with utilities. They've got to get started with the utility company. They may, in fact, start and anticipate starting their real property inspection reports and a survey of the real estate, which will take some time. So there's quite a bit for them to get started on. The sooner that happens, the better. Why is that? Because the sooner they get through that, if there is a closing, the sooner the closing can take place without further delay. During this period, we agree that we're going to be exclusively dealing with them and no other parties. Well, that's essentially what's happening now anyway. And there aren't any other parties that this corporation is dealing with, but it is fair that if they're going to spend their money and undertake this at our request to speed things along, delay here is not their fault. That in turn, we would agree that we wouldn't be dealing with anyone else. And there is no one else to deal with at this point. Confidentiality is a clause that was entered into, would be entered into, so that the terms of this letter of intent would remain confidential to the board. It would not be put up on video or otherwise. You, as shareholders who are in attendance or otherwise that view this video, should know you have a copy of this letter of intent. So it really is already out there, so to speak, but it would not be placed in the public view with their signature or yours. It's a non-binding agreement in the sense that the parties are under no obligation to execute a purchase agreement. And as everyone knows, executing a purchase agreement and a sale agreement requires the shareholders to vote in favor of the sale, and that vote will now take place on August 2nd. So this is a what's called a non-binding letter of intent, but it allows for the commencement of their due diligence at their expense. It allows for this process to continue forward, subject to the vote. And if there is a vote cast, and as I mentioned in the last meeting, over 90% of the shareholders, by the time this vote is taken, will have cast a vote. We're north of 85% in proxies. So this is the largest turnout, and the most important referendum this community has faced. It's clear that the shareholders feel that way. The board made the right decision in taking it to the shareholders. Your documents require 51% passage, as you know, and the shareholders will certainly vote one way or the other, well in excess of 51%, given that there's already 85% turnout by virtue of proxies received. So this vote will be determined come the 2nd of August, and so by allowing this letter of intent to be signed, it simply furthers that they're bound to us from the standpoint of terms. No more rumors that there aren't, that they're pulling out, or that they're not going to pay for the $1 million prepayment penalty on the mortgage, or they're not doing this, or there's a rumor they're not doing that. All of this is in the letter of intent that would be signed by both parties. And the letter of intent, of course, being non-binding, meaning that a vote must take place in order for these terms to be put into a real estate contract, where both parties would then be bound to close the transaction. And remember, at that point, there would be a $3 million deposit that would be put up. So it's a very significant earnest money, $2.5 million, $1 million and another $1.5 million, so $2.5 million in earnest money, with another $3 million to be escrowed for capital improvements. So none of those terms have changed. The board has, of course, been in possession of this letter of intent for many, many months. It was distributed to the shareholders. It's on your videos, and I wish to just, again, express that the only additions to it are access, the exclusivity, and the confidentiality that we talked about before. Okay. I talked about the increase of the money as well for closing costs recovered for the shareholders and other reasons. So we're at the point where I want to entertain any questions on this, because the question will be called to authorize your president to sign it, and then we would seek through their counsel to get ELS to sign it, and we would be on our way at that point, subject to the vote. Is there a motion for this, or any question before we ask a motion from any board member? All right.
I'll make a motion.
Motion is needed. I hear Gary making a motion.
I'll make a motion that the board authorize Bonnie to sign this letter of intent with the early access provision for the ELS.
All right, we have a motion on the floor. We need a second.
I would like to be on record for a second.
We have a second from Mr. Humphreys. Any discussion on this access agreement? All right, hearing none, we're going to call the question then. Bonnie, if you want to go through and call the question for your board, you can hold it.
Okay, we're going to do a roll call vote on this then. I'm gonna start with the people on the phone first. Sandra, how do you vote?
Yes.
Judy?
Yes.
I vote yes. Gary?
Votes yes.
Gary votes yes. Bob? Bob votes yes. David?
Yes.
David Humphries votes yes. Terry? Terry votes yes. So we have unanimously passed the resolution to authorize me to sign the letter of intent for early access for the inspections. Okay?
All right, thank you. So the minutes can reflect that. We will move to the second item on the agenda, which was initially the first item. As was noted, we reversed the order tonight, and that is the termination of proprietary lease and share for certain of the shareholders in default, against whom the termination process has been implemented. Now, we've gone through this before in terms of discussion of the legal procedure. We have also, of course, with the board, specified the individuals against whom these termination proceedings would be implemented. The list is circulated to the board. We're going to start and go in alphabetical order, shareholder by shareholder. And as we go through the process, if there are any questions or comments from board members, we'll look forward to addressing them. And of course, we'll need a motion to terminate, which will need to be seconded, and then will need to be approved each time by 6 of the 7 board members, as a supermajority is required for termination of the proprietary lease and share. Just to remind everyone that if a vote does carry for one or more or all, that the termination is effective by that vote this evening, and the corporate minutes will reflect that. Although that is the case, there is a procedure required under your corporate documents and by law to advance to the point where terminated shareholder makes a decision of whether to redeem their share or not. If they exercise a right of redemption, it is at book value. Book value is $20,000. They also will be subject to eviction if they do not remove their home and or couple a price for their home and share to this board, which the board has the option of accepting as to the home or not. It will be more likely than not this corporation will not exercise the right to buy the home. And therefore, if the shareholder does not remove the home at their own expense, it can be subject to a legal proceeding for removal, costs incurred, including fees, could be redeemed. There would be a lien then against the home. The point is that there are specific legal procedures that are being followed, and tonight we start with the very first one. Each of these shareholders have received a letter of default, a letter advising them that they are being terminated. Each of these shareholders have had the opportunity, over 20 days have passed, well over 20 days now. The requirement was 20 days, it's been almost 30, to allow them to come forward and make their payment. They have not. As a result, they're subject to termination tonight. I would also note the record that these are shareholders that have been in default for some time. And that the amounts that are owed to this corporation are quite extreme for many of them. And therefore, what is occurring this evening is the implementation of legal rights available to this corporation, which simply have not been implemented in the past in your 30-year existence, but have been available to you. And you are undertaking tonight those rights in order to preserve and protect the assets of this corporation. Every shareholder that is terminated, of course, is simply having that occur because of their default. There is no vendetta, there is no vindictiveness, there is no, gee, this is terrible feeling, because to the contrary, the default has occurred for each of these folks for a long, long time. The arrearages are, the delinquencies are quite good. I think Gary has a total there, if I'm looking at it correctly, all of them. Thanks to Gary, I get a report here that we're talking in the aggregate of about $150,000 in arrearages of this corporation. That ain't a small sack of potatoes, and frankly, for many of them, to get to 150, you're talking about some big numbers here. So, that said, they received their termination notices. They've had their grace period extended beyond what the law requires, and they have not yet come forward, any of them, to pay. So, we move forward, and we start with the people listed alphabetically. Is there something you want me to mention?
No, I'm just looking at something.
Oh, I'm good. Yeah. So we're going to move through the list individually, so that each of them has due process if they're here or wish to be heard. If not, of course, as I said, there'll need to be a motion and a second, and then the board will be polled as to each of them, and I'll let you do the polling, Bonnie.
Yep.
But I will go through each of them individually, and I trust that each board member has their list and so forth. They have letters. Keith has been good enough to give us an update on the back of your letters, board members. There is a ledger for each of them with an update, Keith has told me, of the amounts due through the day, which is terrific. That way everyone knows that we're dealing with apples to apples here. All right, the first is going to be lot 759. Lot 759. The shareholder is Connolly. I will not speak to the amount due. Suffice it to say they all owe quite a bit. It is irrelevant right now. What's relevant is the 20 days has expired. Connolly has not made their payment, and we're ready for a motion to terminate the share in the proprietary lease for lot 759. Do we have a motion?
I'll make a motion for lot 759, share 759, and we cancel the proprietary lease for that share, which also terminates the share at this time.
Okay, I have a motion. And Sandra, did you second?
I did.
Okay, so I have a motion by Gary and a second by Sandra to terminate the proprietary lease and the share for Joseph Connolly, lot 749.
59.
759, sorry,
Right.
759. And I will do a roll call vote. I'll start with the phones first. Judy?
Yes.
Sandra?
Yes.
Okay, then I'm gonna go to Terry.
Yes.
Terry is a yes. David?
Yes.
David Humphries is a yes. Bob?
Yes.
Yes.
Yes for
Gary's
Gary.
a yes, and I'm a yes. So we have a unanimous termination of Joseph Connolly, lot 759.
All right, thank you. We're going next to lot 645, Fields. Lot 645, Fields. We'll need a motion.
I'll make a motion for lot
David?
640.
David, question.
Just a second. Go ahead.
Should we denote that this particular person is deceased?
Yes, we can.
The other one was.
Any way, we can certainly note that. Where someone has been deceased,
I think it should be.
there is also here, of course, their heirs are listed. So you can see you have Don and Edward Fields listed under Barbara. So the notices went both to West Palm Beach and up to both Baltimore, Maryland, and Hampton, Virginia.
I think that's important.
Okay, and the notices are part of your corporate records, and they reflect the attempts to reach the heirs, so, yes. All right, we have a motion for Fields, all of them named Fields. I'm sorry, go right ahead and repeat your motion if you would, Gary.
Yes, I make a motion for lot 645, share 645, that we cancel the proprietary lease, thus terminates the share.
Second.
Okay, I need a second.
Second.
Take your Terry second this time. Okay, and we will, I have a motion and a second, and I will do a roll call vote. I'll start with Terry this time. Yes, Terry. David?
Yes.
Yes from David. Bob?
Yes.
Yes from Bob.
Yes, from
Yes from Gary. Now I'll go to the phone. Judy?
Yes.
Sandra?
Yes.
And I vote yes. So we have unanimously supported the motion to terminate the lease and the share of lot 645 Barbara Fields.
Thank you. We're now move on to lot 806. Again, we have a deceased shareholder with another party, noted who is alive. They have been notified. These are long-standing arrearages. Lot 806. And we now need a motion to terminate both the lease and share for that.
I'll make a motion for lot 806, shareholders 806, that we cancel the proprietary lease for a cause of non-payment and thus terminate the share.
I'll second.
Okay, so I have a motion by Gary and a second by Dave Humphries to terminate the proprietary lease and the share for lot 806. I'm doing a roll call vote. I'll start with the phone this time. Judy?
Yes.
Sandra?
Yes.
Gary?
Yes.
Bob? David Humphries?
Yes.
Terry Langton?
Yes.
And I vote yes, so that's unanimously. We have approved the termination of the lease, proprietary lease, and the share for Joy Golden, lot 806.
All right, now we will move on to the next one, which is lot 1101 Gorlick.
Deceased.
We will note again, for the record, deceased with an heir, second party noted, that was also notified Juno Beach, with nothing forthcoming from anyone. We are moving in support. We ask for a motion to terminate the lease and share for 1101.
Yes, I'll make a motion for lot 1101, share 101, to cancel the proprietary lease for cause for non-payment and also terminate the share.
There's a motion, can I have a second?
I'll second that motion.
Okay, I'll take Terry's second. So I have a motion and a second to cancel the proprietary lease and terminate the share for lot 1101, share 101, Lorraine Gorlick. Now I'll do a roll call vote, and I'll start with the phone. Judy?
Yes.
Sandra?
Yes.
Terry?
Yes.
Yes, and from Terry. David?
Yes.
Yes from David. Bob?
Yes.
Yes from Bob. Gary?
Gary's yes.
Gary's a yes, Bonnie's a yes. That's unanimously approving the motion to terminate the proprietary lease and the share for lot 1101, Lorraine Gorlick.
All right, next we're moving to lot 1102. I think is,
Is that correct? But the next one down there. Oh, that's the
that's the other,
address.
that's the
1102 is
other.
okay. We're okay with that.
Okay, so now, 1102, Guida, deceased, second party noted. on there as well that was notified. However, nothing forthcoming, we now seek a motion to also terminate this particular share in proprietary lease.
I'll make a motion for lot 1102, share 102, that we cancel the proprietary lease for cause for non-payment, which results in a termination of the share.
Second, any second?
I second that
I
motion.
will second.
Okay, I have a motion and a second to terminate the proprietary lease and the share for, Guida lot 1102. All right, let's do a roll call vote. Terry?
Yes.
Yes for Terry. David?
Yes.
Yes for David. Bob?
Yes.
Yes for Bob.
Yes for Gary.
Yes for Gary. Now to the phone. Sandra?
Yes.
Judy?
Yes.
And I vote yes, so we have unanimously approved the termination of the proprietary lease and the share for lot 1102 Guida.
All right, thank you. Now, we're moving down the list to the next one. This is Menden Hall, lot 1125, also deceased, no heirs. Did I miss Landine? All right, well, let's go back to Landine. We don't want to miss Landine.
I'm here for Landine.
Okay,
All right,
all right.
we have Landine. Yes, I'm going to ask for, let me repeat, Landine is a lot 1248. And the arrearage is noted in the letter. For today, we're going to look, there's someone here for Landine, so I want to pull up. The amount of 6493. Okay, is there someone here that wants to be heard on behalf of Landine?
Yes.
You wanna come up here so you can speak?
That or I hand him a mic. Where? I'll come on up.
We need to record it.
Oh, you want him
I
recorded?
want him up here.
Oh, okay, I'm sorry.
Want him on camera.
That's okay.
Is that what
First things first, what time did this meeting start?
6.
o'clock, but you're here.
Letter from the attorney told me 7 o'clock.
Okay,
I went to talk to your
sorry.
attorney.
That's all right.
Sir, you can come right up here.
Right here, okay. Hi, everybody. Oh boy, I've never done anything like this. I'm quite nervous.
Would you repeat your name?
My name is Jeffrey Desmond. My mother is Eileen Landine, who previously resided at lot 1248. Her husband is Robert Landine. The family knows him as Pete, so if you hear me mention Pete by accident, that's actually Robert. The reason why I have legal power of attorney over Eileen, she is currently, let me back up a bit, and I'll try to keep this short. Robert Landine has been in a nursing home for approximately 26 months. He has advanced Alzheimer's disease. He's deemed medically incompetent. He can't make his own decisions. Eileen went into a nursing home last November. She was registered with hospice in February. She's battling lung cancer, COPD, a bunch of other illnesses, congestive heart failure. We are behind on the payments, and I'm not going to contest that. I'll be honest, there's no way. I'm representing my mother. Robert has a daughter in Massachusetts. Her and I talked. We know we can't save the property. We're not going to try to save the property. We have no way to come up with the money. The money's due. We're not going to argue that. I showed up tonight because there was some verbiage in the letter from the attorney that I was wanted to see clarification on. And I guess I would address that to the board. Pursuant to Article 7, Section 5A of the bylaws, you shall have the right to either 1, sell the cooperative only your certificate, or number 2, sell the cooperative your certificate and your mobile home located on the lot.
Right.
The situation Robert and Eileen are in right now, they're both under Medicaid care. They owe a small mortgage. They owe the board, obviously. They are behind on their taxes. The family has no way to pay it. We're willing to surrender the property, but we would. I'm here to try to see if there's a way the board can work with me so at least I can pay off, Wells Fargo on the mortgage. So
Sure.
They're
Let's
dead
do
getting
this.
paid.
We appreciate it, understand completely your concerns and your desires. Let us go through the process this evening, given that you acknowledge that you can't make the payment. We'll go through the termination today. There is a redemption period. We'll talk more with you about perhaps being able to work something out. I'm sure we can.
Okay.
That said, we need to go through the termination process.
I understand
Okay,
that.
so when we're done, I'd be glad to, we're done with all of them.
Okay.
Why don't we spend a few minutes with you, and I'd like to get your contact information, and we'll take care of that, okay?
What was your name, sir?
My name's David Bernstein.
David
I am
Bernstein, okay, thank you.
counsel.
And one thing I want to make clear with my parents, and then we'll get to your question, with my parents, both
Yes.
in Medicaid, it was our intention to try to sell the house, but even if we sold the house, the
You
state
get the
wouldn't
money.
take any
You
money.
get the money,
Yeah, so the
absolutely.
family, between me and Robert's daughter, neither one of us have anything to gain or anything to lose here.
That's right.
There's no profit to be made, we have no exposure. We're here simply to try to
No,
maybe
and
become our adventure, our
I
grandson
tell you, I
died.
appreciate fully what you're saying, where you're coming from, and again, this is not intended to be in any way a hardship or vindictive.
Yeah, I don't
No
argue
one's
the,
coming-
the delinquent.
You
I
don't
don't
argue
argue
the
that.
delinquency, so that's fine. We will work with you.
Okay, I appreciate that.
You betcha.
Are you at liberty to tell us how much the balance of the mortgage is?
I can give you a ballpark,
That's close enough.
just a ballpark figure, the mid $30,000 range.
No, we don't.
What about tax?
We won't be able to take care of that. We'll, taxes.
Okay,
But you have no personal liability over that.
I do not, I've never signed anything. I have power of attorney over Eileen, she's.
I understand.
That's fine,
my
okay, yeah,
vote.
We can work. The
we'll
banks
work
normally
with
take
them.
a deed in lieu, so that'll be fun.
Okay, who wants the mic back?
We just have the mic back here, and we'll, if you want
We'll
to
have to
table
look it up,
after,
Rob.
we'll.
All right,
Thank you for your time,
thank you, sir.
Appreciate you coming.
Appreciate it. Okay, so now, just to go back, we heard from the power of attorney, but we needed a motion to go forward now and terminate the share in the lease, so I'd like a motion.
Yeah, I would make a motion for a lot of 1248, share 248, that we cancel the proprietary lease for cause of non-payment, which would result in a termination of the share.
I will offer a second and voice an appreciation for this gentleman coming.
Gary, you said 248, it's 1248.
Well,
No, it's
1248, but the share.
1248 is the lot, the share is 248.
248.
Right. If you have a 4-digit lot number, your share is.
What the lot number, your share number is the last three numbers.
Right.
Okay, that's why. Share number.
We have
I second.
I know that.
Okay, so I have a motion, and I have a second from David Humphries, to terminate the proprietary lease and the share for lot 1248, Robert Landine, and we will do a roll call vote. I start with the phone. Judy?
Yes.
Sandra?
Yes.
I will vote yes. Gary?
Gary votes yes.
Gary votes yes. Bob?
Yes.
Bob votes yes. David?
David votes yes.
Sandra?
No, Terry.
Terry, I'm sorry, I already said that. Oh my goodness. So Terry down there votes yes also. He's like, keeps bringing it up there. Okay, and so we have had a motion, a second, unanimous approval, and we will terminate the proprietary lease and the share for lot 1248 with the addendum that our council and the board will work with the power of attorney to deal with the issues that he brought forward.
Absolutely.
Okay.
Okay, and to think that I almost skipped over Landine, which, has been the highlight of the night.
The letter's at 7 o'clock.
I'll tell you also, just so that you know, it was at 7 o'clock. It got amended, the notice got posted back, and it was reset for 6. You
Okay.
just didn't know that. But you should know, it's probably worth noting for you, that we reversed the order. That we were going this evening, we were gonna start with the terminations and then go to a second agenda item. And we actually started with an agenda item that took some time, which allowed you to get here.
I've been sitting in the
Because
car.
I saw you come running in.
Yeah, I didn't want to be too close.
And you would have been, we would have still heard you, and we would have still done it, but it worked out pretty good for you. Okay, so
Thank you.
that is good, that we did not skip over Lundin. Let's go to Mendenhall. Mendenhall, 11:25. Are you here representing them too, or no?
I'll be back in half an hour.
All right, so we have Mendenhall, notice given. Mendenhall is noted as deceased. No heirs forthcoming. We're into a big rearage here. So now we're looking at the need for a motion. This is lot 1125 to terminate the share in the lease.
I'll make a motion for lot 1125, share 125, and we cancel the proprietary lease for cause for non-payment, which will result in a termination of the share.
Second?
I second that motion.
I'll get it right, Gary. Okay, so we have a motion by Gary and a second by Terry to cancel the proprietary lease and terminate the share for Mendenhall lot 1125, share 125. We'll go through the roll call vote. I'll start with the phone. Sandra?
Yes.
Judy?
Yeah.
Terry?
Yes.
David?
Yes.
Yes?
Yes.
Bob?
Yes.
Gary?
Yes.
And I vote yes. So there's unanimously, we have voted to terminate the proprietary lease and the share for lot 1125 Mendenhall.
All right, very good. We are now moving to lot 475. Morgan, also noted as deceased, does have an heir noted in Palm Beach Gardens. No response or payment having been forthcoming. We are now moving toward the termination of the share and the proprietary lease. So I'll need a motion for lot 475 to do that.
I'll make a motion for lot 475, share 475, that we cancel the proprietary lease for cause for non-payment, which will result in a termination of the share.
I second that motion.
Okay, I have a motion by Gary and a second by Terry to cancel the proprietary lease and terminate the share for lot 475, Rita Morgan. We'll do a roll call vote. I'll start with the phone. Sandra?
Yes.
Judy?
Yes.
Terry?
Yes.
David?
Yes.
Bob? Gary?
Yes.
Bonnie? All yes. So there's been unanimous approval of the motion to terminate the proprietary lease and the share of lot 475, Rita Morgan.
All right, very good. We're now moving to lot 659, Stedman. Stedman, I would also note deceased, no heir, no one coming forward on behalf of Stedman. Very significant rearage here. Many years have passed. We now need, in light of that, a motion to terminate the lease and hence the share at lot 659.
I'll make a motion for lot 659, share 659, that we cancel the proprietary lease for cause for non-payment, which will result in the termination of the share.
I second that motion.
Okay, I have a motion by Gary and a second by Terry to cancel the proprietary lease and terminate the share for lot 659, Stedman. And we'll do a roll call vote. Let's start with Sandra.
Yes.
Judy?
Yeah.
Terry?
Yes.
David?
Yes.
Bob?
Yes.
Gary?
Yes.
And I am a yes. So that's unanimously approving the termination of the proprietary lease and the share for lot 659, Stedman.
All right, so we have completed the terminations for this evening. There were 9 successful
motions, and hence 9 terminations. It's a significant amount of money that could become available for distribution should this transaction go forward by affirmative vote on the 2nd. I would note, 2nd of August, I would note there's another list that will be going out shortly for, I believe by tomorrow, letters will be sent for another list of delinquent shareholders with mounting delinquencies. They're being reminded there are about 14 on that list. We check our list twice. We know if you're naughty or nice. If you haven't paid your arrearages, you are subject to termination. I think Gary gave the admonishment in the last meeting, correctly so. Pay your taxes, pay your maintenance fees, don't fall in arrears. But we have a list of shareholders who have unfortunately qualified for termination and will be receiving letters to that effect shortly. All right. Anything left this evening on the termination agenda?
I was going to say, these, the letters that are going out tomorrow, these 14 people will have the opportunity to cure their accounts, and we will schedule a meeting for July 12th, where we will have exactly the same as tonight and go through for termination on any of those that do not cure. We did have, for example, we had a number of other people that we originally started out with before tonight's termination and ended up with 9. So people do have the opportunity to bring, the shareholders, I'm sorry, shareholders, have the opportunity to bring their account up to what they owe us and what they owe in taxes prior to us doing the termination. Yes.
And we also note for that meeting, the time to be.
Yes. We will do, that meeting will be July 12th at 6 p.m. And I'm sure that they have it correct. Yeah, it'll be posted.
Okay. It'll be posted July 12th is a Thursday, 6 p.m.
Right.
All right. That concludes our agenda items for this evening. You'll get a motion to adjourn.
Yep. Would like to give me a motion to adjourn.
I'll make the motion.
I'll make the motion.
Okay, I have a motion. Do I have a second, Terry?
Yes.
I have a motion to adjourn and a second. All those in favor?
Aye.
Aye. Anybody opposed? Meeting is adjourned at 6:45. Okay, now I will take some questions from the floor. Okay, Matt, you want to? Oh, he's gonna go around.
Matt Tanker, lot 521. Just a little clarification. You terminated the leases. I wasn't quite sure on what you said earlier. Was the, they would still have the right to pay off their fees?
No, that's over. The only thing they have right now is the opportunity to have their share in the home. They have the option to come forward and seek a redemption. We have the option at that point to give them book value for their share and to determine if we want to pay for their home or not. Book value would be deducted from any arrears, so whatever they owe would get deducted from the book value. But their share is terminated effective as of tonight.
If they find them.
So they can no longer pay off and get anything
That's right.
back?
They can no longer be a part of any distribution, which I think where you're going.
All right, thank you.
Go ahead.
Yeah.
Yeah, this question is directed
Say who you
at
are. Let's say who you are first.
Ed, lot 1225.
Thank you.
In light of the financial market going in the direction it's going and 2 more potential increases in the prime lending rate, it behooves me as to why the board hasn't reacted to this, and why don't we cash in the assets that we have on the bonds. We're going to take a beating on the penalty anyway because we're going to do it early. And secondly, take that money and lock it up to where you can't touch it for anything, and at least we'll have something, because we're on a slippery slope here, and we're just losing money. So I would ask the board to consider that.
Okay, I will take that recommendation, and it will be handled by the Finance Committee.
By the way, who's on the Finance Committee?
Okay. Judy, do you want to tell me so I don't say something wrong? Can you tell me who's on the Finance Committee right now?
I don't think we have a finance committee.
Oh, okay, because I thought you did, but there's some, I know there are some people that haven't been on it. So, okay, do you want to form a committee then?
Barry will be on.
We can't have, you need these. Oh, that's fine. But we can't have two ordinances. Yeah. So that we have,
Terry is volunteering. Do you want to put together that committee? Because if, Gary, are you wanting to be on it? You were in the past. You don't. You resigned. Okay. So we have Terry and you, but I don't think we should have any more board members, so we end up with issues related to open
well, that
meetings.
wouldn't be a quorum.
Three. Yeah,
Three. You're gonna have three. David, I have one other question, and this is in regards to the letter of intent.
Okay, just a second.
Judy, who would you like else to be on the Finance Committee?
It doesn't matter to me whoever's on the put in the bonds. At this point, the only thing we'll be talking about will be the bonds, so.
Okay, so do you want to contact somebody after this, or do you want to put somebody on now?
I'll contact them then.
Okay, all right, so we'll leave that with you as the treasurer. Okay, now,
All right,
Now.
on the letter of intent, predicated on the August election, you made the comment about the approximate $3 million that they were, ELS is going to pledge at that point in time.
They're gonna put up $1 billion, it'll be, as it's gonna work out, actually $2.5 million.
Right, okay, I understand
And then
that.
the $3 million is for capital improvements, so.
I understand that. My only question is, once that commitment is made, and unfortunately, if we got hit with a hurricane or anything of that nature, what is the status of that money at that point in time? Are we still entitled to it? Do you have wiggle room to get out of
They have
it?
wiggle room to get out of it.
Thank
because
you.
There will be.
That's all I wanted to know.
Yeah, and I think that's right. I think it's important for everybody, you understand, but others may not.
I
So I'll just embellish that Ed used the word wiggle room means if there was a casualty here, could they get their money back? Yes, the risk of loss due to a hurricane remains with the seller in a commercial real estate contract. So that if God forbid that happened, they could, as Ed said, wiggle that.
Thank you.
do you still have another question? Go ahead.
Jimmy Frick, on 1260. If someone has a share already, and it's in good standing, and they want to buy a mobile, that is permissible, right?
So they want to buy the mobile and transfer the share? Is that what you're saying?
Right, they own a share.
Okay. So they want to
They don't have
transfer
a
the
mobile
share?
on
Okay, they own a share, but they don't have a mobile on it, but they want to buy a mobile and transfer their share. Yes, that is permissible.
That's permissible.
Because they already own the share. What we have the moratorium on is we are not issuing any shares. Anyone that has a share can move it.
My name is Barry Barnhart, lot 1234. In here it says if we might have to do 2 or 3 more times. This is the second time. Is there going to be a time where we're going to cut it off?
I'm sorry, I still, so what is your question? Something about a second time?
second
There
session.
could be a second or even third batch of possible terminations.
Okay, there could be, and we're talking about, this is the first terminations. The second terminations, we've already talked about, will be July 12th, Thursday, July 12th. And we could have a third set of terminations still before the closing.
Will there be a date where we're gonna cut it off?
Yeah.
If it's sick?
Yeah. Hopefully we won't have that many people left that owes us thousands of dollars. I mean, the next thing that we have an issue with after this next set of terminations is people who have issues where, have tax issues with certificates because the co-op would have to pay them off. So that might be the next thing we're looking at. So pay your maintenance fees, pay your taxes. There will be no distribution of funds to anybody until everything is paid off. I mean, if you're in good standing, you'll get your money, but if you owe thousands of dollars to the co-op and you owe a lot of taxes, that will all have to be up to date before you would get any money distribution from the sale. Any more questions? I got somebody over there. Oh, behind you. I'm sorry. Well, you got somebody behind you if you want to quick, don't have to run so much. I'll let her go first so we keep Gary in good standing here.
My name is Barbara, I live at lot 1089. I just have a question to know approximately how many people are in delinquencies as of now?
Delinquency. Well, we have considered a delinquency anybody that has to be, have to be over 90 days. But I know that we got a list from when we had the title company do a list of people that owed taxes. He had 80 people who owed taxes of more than a year. Now, why that is of importance to the shareholders is we cannot close on a property if there's taxes due on it. So the co-op is going to have to pay every one of those taxes off before we can close. So it's very important that we follow through on this and get anyone who owes taxes to pay their taxes. We can.
Because the non-payment of taxes, as Bonnie said, comes out of your pocket, so for every shareholder who doesn't pay, it comes out of the pockets of the corporation to close it. So in effect, the good shareholders who have been paying, and they're paying for those that haven't. No. Bob, hold on.
We're gonna let Bob ask a question.
Bob's volunteered to pay those things.
Obviously, they can't bring their debt up to the table once they take it out on a check.
No.
What about taxes?
Same thing.
See, we have to
Can't pay
pay
it out
that.
of the check, can't pay it out of the check because there's no check, they have to be paid before the check. Now, what we can do, in a worst case scenario, obviously they're going to be charged one way or the other. But if we told folks you didn't have to pay, and it'll just get taken out of your check, no one would pay, they'd all be waiting for the check. So we have to go through this legal procedure to protect the corporation and your assets. So, and frankly, make people do what they're supposed to do. Because it's not this corporation's responsibility to pay individual taxpayer taxes. And that's why you end up broke if you do that. So anyway, yes, sir, Ed?
Yeah, in light of what David's talking about, you're gonna end up with that situation, fortunately, if we can close sometime in November, because we'll get our new tax bill by that time. Now, in my way of thinking is, I'm gonna go ahead and pay it.
No. Your tax bill that you get in November is not due until April.
I understand that.
But you do get a discount.
It's a 4% discount.
Right,
But
but
pay taxes in arrears.
if you're closing at that point in time and you got the outstanding tax bill there, it's not delinquent, but you still have the tax bill there. Now, say for instance the person doesn't pay it, and then they get the buyout, and then they go delinquent in April.
Well, that's not on your watch at that point.
I understand that, but it is on my watch because it'll inadvertently come back through as a through charge at some point in time.
Well, there could be a need for reproration. We'll be covering that in the contract, yeah. But I hear what you're saying, and it will protect for that, but I want to make sure everyone understands, you know, there is a chance we'll be closing in November.
Right.
There is a chance, and you will, I think, have your bills, because it could be December, it could be November. If they start to due diligence early, like we voted on tonight, it'll be October. I mean, there's no reason this couldn't go quicker now, because we voted through a measure this evening to try to move this along quicker, and they have shown their interest to do it. So, but either way, you're right, tax bills could be out. But the important thing is this, taxes have to be paid by the taxpayer.
I understand that, but I'm a little confused, David, because do I pay the tax bill when I get it?
We're going to have another meeting to talk about that.
Okay, thank you.
Believe me,
Thank you.
we're going to have a few more workshops that we'll cover that as we get closer. Let's see where this ball's going to land in terms of closing day, okay?
Okay, thank you.
Yes, sir. Gentleman here in the green shirt.
My name is Ken Brown, 1316. My question is about the lease that you sent out with the proxy vote. It was very, very vague. Okay, once we vote on it, and that's what I understand, is that can't be filled in until we vote. But then when we have like could we go back and rescind our vote if that contract is not satisfactory?
Yeah, I'm happy to answer that. There isn't a rescission of the vote. I mean, when the vote takes place on the 2nd, that's the vote. The lease you have is the lease. If you have any questions on it, I'm glad to address it with you. It's approved by the state of Florida. It's not intended to be ambiguous. The blanks you see, if that's what you're referring to,
yeah,
blanks by the dollar amounts, the blanks that are there are for charges, some of which applies, most of which don't. If they're not checked off, there's no such charge for you. You know, there's things in there like a return check fee or things, you know, that type of charge. But the contract specifies who pays what, and those terms aren't changing, you know, as far as lawn mowing, as far, you know, those types of things.
I'm talking like, let's say,
cable.
Okay, you know, the cable is one,
Yep.
the
Base cable's included.
compound for the boats and the RVs.
It's all
You know,
included.
is that something that they
It's all
come back and say,
no,
well,
that's, no,
now
no.
we're gonna charge for that?
No, sir. As a matter of fact, to your question, the letter of intent that was approved tonight for signature contains those exact same facts, and that's why it's important we did this tonight, so that the rumors or worries, which are completely understandable, it's understandable that you would, every shareholder should want to be sure that's the case, is in the letter of intent. It's going to be signed, right, David? And therefore, there is no change in anything, all right? When we get to the vote is based on this letter of intent that's been circulated. There is going to be a follow-up letter that you're going to receive, we hope, as early as next week, that will address a few issues for every shareholder to consider with regard to their vote. Have you given a proxy, for example?
No, I have not.
Okay. So you intend to probably vote by ballot if you're going to vote at all?
Yes.
Okay, fine. So everyone, whether you voted or not, will get this letter, every shareholder, unless they've been terminated, every shareholder that has not been terminated will get this letter that will give some update, financial update. But I will assure you that the terms that you're speaking to are contained in the letter of intent, will be in the contract, it will be what will be binding to the new owner and the shareholders, all of you going forward. So that isn't changing.
Okay, thank you.
Yes, sir.
We get Beth here. I take one more and then we're gonna be done.
Okay, we'll take Beth and that's it?
Yep.
All right, Beth.
Beth Barry, lot 1123. David, when is the time going to be allocated to change the names on our shares?
Right. Thank you for asking that. And it's kind of dovetails Ed's question about taxes. We're going to have some fun. After the vote goes through, we're going to have a few follow-up workshops. And one of them is, of course, the share modification workshop. We're going to do that likely in September. Okay? Give everybody plenty of time to get through the first, just so everyone understands the sequencing. We have to have the vote before we do that. The vote's August 2nd. Then the contract's going to get submitted, negotiated, terms are already agreed to, and executed. At that point, we're gonna schedule some workshops going forward. We'll have about 60 to 90 days before there would be a closing, more closer to 90, so August, September, October, into November, as Ed said, likely, maybe even end of October, more likely November, December closing. Plenty of time for that workshop. I want to have it in early September though, so let's say maybe the first week of September. Now remember, a lot of people aren't back yet. So the video will be available for them. We'll be doing some bailouts for them. And we'll have the ability to change those shares all the way up to the closing. But you'll be here, Beth. And those people that will be here, obviously, live here year-round, will be here in September. Those that are still up north, well, if they're not back by October or November, I can't do anything about that. But I'll do my best to be sure they're given the forms and they'll be able to mail them in. Right? They'll do a mail away to them, and hopefully they will. But we'll have workshops. Yep.
Thank you all.
What about any of the ones that terminated? What the question was, are there any active tenants?
There is no active tenant. I mean, we have some that don't have a home on the share either. But it's illegal. We do have an illegal tenant.
Yes.
The illegal tenant will be evicted. When and there might be other people, as they listen to that tonight, and are aware there's an illegal tenant. We did start processing to evict that legal tenant, but that's a whole different legal thing to evict a tenant. We are on much better standing with the courts now that we have terminated the share and we can follow through with our bylaws process, that the court will not be there to interpret the eviction. This is one of the problems we had in the past with evicting some people that we had a lot of trouble with. The court kept giving them more and more time. In this situation, when we have terminated the share, it's all in our bylaws. We just follow when they're gone. So 45 days. 45 days for that person to be gone before we get the share.